Till now, we have seen the structure of the International Court of Justice, which is the principal judicial organ of the United Nations. Now let us look at the various functions which are exercised by this International Court of Justice. Now, the International Court of Justice draws its powers and functions from the United Nations Charter and its annexure or addition, the Statute of the International Court of Justice. Before we look at the various functions of the International Court of Justice, we have to understand a legal term, which is jurisdiction. Jurisdiction is a legal term which refers to the official power to take legal decisions and judgments. Therefore, jurisdiction is a power given to a particular body or organization through which it can take legal decisions and judgments. The International Court of Justice exercises its various functions through such various kinds of jurisdictions, as we will see now. We will start our discussion with the compulsory jurisdiction of the International Court of Justice. The compulsory jurisdiction of the International Court of Justice applies to those cases where the International Court of Justice automatically takes up the case on its own and it does not require any reference made by either of the parties involved in that particular case. This compulsory jurisdiction of the International Court of Justice is also known as the original jurisdiction. However, this compulsory jurisdiction of the International Court of Justice only applies in those disputes that involves the states that have accepted this compulsory jurisdiction of the ICJ. So either sides have to accept this compulsory jurisdiction before the International Court of Justice could take up a case or a dispute upon its compulsory jurisdiction. Now, how does a member nation or any other state accept the compulsory jurisdiction? Well, they can do that either in full capacity, where they accept the compulsory jurisdiction on all cases which might apply on them, or they can do it in a partial capacity. So till now, about 72 states have accepted this jurisdiction in full, while other nations have done this partially, including United States of America, who have accepted this compulsory jurisdiction in a voluntary format. And thus this can only apply to a certain kind of disputes and only in some legal matters. Now, apart from accepting this compulsory jurisdiction in a partial capacity on their own, there is another way this can work out, which is through signing certain treaties, especially those treaties which have a clause that if a dispute arises in that treaty, or if any nation does not abide by the various terms of the treaties, then that dispute shall go to the International Court of Justice. Therefore, even if the member nation does not accept on its own this compulsory jurisdiction, by being a signatory of that treaty, they have to accept it, because the treaty itself will get its dispute resolved from the International Court of Justice. Now, can you answer this question? How many states have accepted the compulsory jurisdiction of the International Court of Justice in full capacity? Is it 50, 72, 62, or 75? The correct answer is 72 states. Now, this compulsory jurisdiction of the International Court of Justice also extends to those disputes, especially the ones pertaining to the urgent interpretation of international law, and also the ones which involve the settlement of compensation whenever a breach of any treaty occurs. Now, we saw how a member state or any other country can voluntarily opt out of this compulsory jurisdiction of the International Court of Justice, even though the verdict or the judgment of the ICJ is binding on all the parties involved and also any other member nation that has ratified the Charter of the United Nations. The jurisdiction, which is the power or the capacity to make this judgment, that isn't binding on every nation. That can very well be opted out. Now, why is this the case? Does this not make the jurisdiction or the capacity of the ICJ less effective? Well, this is done because every nation in the world is a sovereign power, and therefore the ICJ cannot act as a power above all, and therefore this option of opting out of jurisdiction exists. That is why in reality this compulsory jurisdiction of the International Court of Justice is in reality a consensual jurisdiction which does not apply as long as both sides or both parties do not accept this jurisdiction. In reality, most of the cases which the International Court of Justice takes up falls under its voluntary jurisdiction. These are those cases which the International Court of Justice does not automatically take up on its own and instead needs to be referred to the International Court of Justice by one of the two parties which are involved. In any case or a dispute, there are two parties mentioned, and either of these parties have to first refer this case to the International Court of Justice before it can decide to take it up. Why is the word can mentioned? Because it is up to the International Court of Justice to decide whether it wishes to take up this case or whether it wishes not to do so. Even if the International Court of Justice takes up the case, it will not sit for a hearing until both the parties are physically present before the court itself. What happens if either of the parties fails to present itself before the court? In that case, the reference is not acted upon and is merely filed before the court itself. Now, the International Court of Justice is the principal judicial organ of the United Nations, as has been mentioned multiple number of times. And therefore, the International Court of Justice sits at the top of the judicial hierarchy of the United Nations. Now, often is the case when the other United Nations organs, such as the General Assembly and the Security Council, have to face pertaining legal issues and questions. Now, while these organs have their own legal wings as well, sometimes the legal questions which face them are beyond the competence of the legal wings and might take up too much time of their own. Therefore, sometimes these other United Nations organs or the various specialized agencies of the UN, such as WHO or UNICEF, since they are primarily executive and legislative in nature, cannot deal with pressing judicial questions and need some form of effective legal advice to ensure their smooth functioning. And that is where the advisory jurisdiction of the International Court of Justice comes in. So we see that the UN organs like General Assembly or Security Council and various other agencies such as UNICEF or WHO may request the International Court of Justice to give its advice or opinion on various legal questions. But when does the International Court of Justice really need to give the advice? Well, the International Court of Justice uses its advisory jurisdiction mostly in those legal matters which require the interpretation of international law. Now, the International Court of Justice can simply choose to refuse to give its advice or opinion on any legal matter if it feels that the question being asked does not require an interpretation of international law or is simply too contentious or unnecessary to ask in the first place. Now, the International Court of Justice is often referred as the guardian and the interpreter of international law. And thus, it is the task of the International Court of Justice to uphold and make all nations abide by international law. Now, apart from upholding the international law whenever necessary, the International Court of Justice also does the crucial task of codifying international law, which means to keep records of international law. This is a very excruciating task as international law is very dynamic and ever-changing. Now, how does International Court of Justice really codify the international law? This codification is done after thorough examination of international conventions, customs, and also by looking at various past judicial decisions pertaining international law. This function of the International Court of Justice often earns it the nickname as the living constitution of international law itself. Now, the most important function of the International Court of Justice pertains to its settling various disputes between two nations. Now, the International Court of Justice attempts to settle these disputes in a peaceful manner between the countries by making both parties come to an unanimous agreement. Now, in executing this function, the International Court of Justice abides by the Pacific Settlement of Disputes mechanism, which has been put forward by the United Nations Charter itself, in which it uses methods of arbitration and peaceful judicial settlement to truly bring disputes to a resolution. Now, as the International Court of Justice is the guardian and interpreter of international law itself, all the dispute resolutions are done in accordance with international law, and in fact both the parties are given ample facilities to put forward their case, so the justice which is served is fair. And the verdict which the International Court of Justice serves is binding on all parties and also all the other states that have ratified the United Nations Charter. Therefore, whatever justice which is served at the end of a case, this particular verdict is binding on all parties, and they thus cannot disregard this judgment. Thus, the concerned parties and all the other states who have ratified the UN Charter, they are obligated to comply with the International Court of Justice's decision or its verdict. Over here we see a picture of Nobel laureate and erstwhile Foreign Affairs Minister of Myanmar defending her country's military against genocide allegations made towards it during the Rohingya crisis. However, the verdict which was made by the International Court of Justice was binding on her government and also the other party involved. But what happens if a party decides to disregard the verdict or the decision made by the International Court of Justice? Well, disregard is considered equivalent or on the same scale as disregarding the United Nations Charter itself, and thus this disregard could lead to that country's expulsion or removal from the United Nations itself. So thus we saw the various functions of the International Court of Justice, the principal judicial organ of the United Nations. We also saw how different kinds of jurisdictions apply to the various functions. In a subsequent lesson, we will be looking at the various other organs of the United Nations organization. Don't forget to subscribe to our channel and hit the bell icon. You can also register for free at DeltaStep.com or download the DeltaStep app to learn one-to-one with our amazing teachers, or to get access to all our 5,000 plus amazing videos as per your school syllabus. Master each topic with our adaptive practice technology. Get million plus questions with step-by-step solutions and unlimited mock tests. Get all your doubts resolved instantly. Learn via games and win amazing prizes like PlayStations and iPads. So at DeltaStep, learning is not just fun and easy, it is rewarding too. So register for free now.